Hi folks, you're with Tacitus today, your pushback channel, and thank you for joining this audio live stream. Please listen to this presentation as you would a radio broadcast. In this essay, I'd like to talk about the increasing use by courts, hitherto courts of law, but now courts of ideology, given all the activist judges and activist prosecutors around the place, all over the Western world now, is the use of assumed or ascribed intent. You intended to do this. You will intend it. Your intentions are, your intentions were. And they can do this, just simply ascribe it. And once they do that, they at the same time reverse the burden of proof. So we say you intended to do such and such. Now you have to prove you didn't. But there's no evidence to prove that you had any such intention or you did anything to suggest or imply such an intention. But they can do that. And this is the device they use to get people that ideologically are on the wrong side of the narrative, or to let people go free who are on the right. So the BLM activist that sets fire to the building or slaps around people in there, or throws bricks at this and creates disruption at that, and refuses to let the firefighters cross the barriers so they can put out the fire, all this sort of stuff. So many of these BLM activists, certainly over the years, have gone free. In many instances, not even having a misdemeanor or something recorded. And if you read some of the reasons for judgment that the activist judicial officers, judges, put forward, it's Billy Bob didn't intend to do bad. Billy Bob was there to fight fascists, to fight Nazis. He was there to stop the Nazis. That's a good thing. His intentions are good. He's stopping Nazis. But can somebody prove that there were any Nazis, or what? It doesn't matter. We can just say that. He said that. His lawyer said that he's there to stop them. That's a good thing. So really, okay, he broke the law technically, but his intentions were good. He was trying to stop fucking Hitler. That's what he was trying to do. So those are good intentions. That's good. His heart's in the right place. So even though he broke the law, sure, but you gotta break a few eggs if you're gonna stop Hitler. Holy crap. So we're going to let Billy Bob go, and we're not going to fine him or anything like that. He got free legal aid, and his bail money or whatever, his arrest, his bail money was all covered by some NGO. So Billy Bob just walks out the door, and that's the end of it. Billy Bob's free to go out and do it all again, which he does. So by the use of saying his intentions were good in this case. Now, if you come from a supposed social victim class, Billy Bob just happens to be a black guy. But if you come from a social victim class, that's again an ideological determination, not a factual determination, then they're going to cut you a lot of slack. So when a supposed transgender man goes into a man claiming to be a woman, I think it is, yes, it is, goes into a woman's change room, they can change the evidence bar to a very high level in order to bring about where the prosecution has to prove a case. So, okay, there's no disputing that a man went into a women's change room. Okay, we're not disputing that. There's no dispute that the man undressed in front of women, including minor children. When I say minors, I don't mean like tiny children, but women under the age of 18 or under the age of 17, it might have been. And also a claim that he got a partial hard-on, but not a full hard-on. So the argument was, well, his intention to cause sexual distress or to sexually harass the women there, because his hard-on wasn't, blue steel, he wasn't going rock hard. He was only going, half rock hard or less than rock hard. Therefore, his intention can't have been to engage in unwanted intimate relations, because to do that, you'd have to be rock hard. This guy wasn't rock hard. Therefore, no crime committed, because he didn't intend. He didn't intend to, otherwise he would have been rock hard. So there you go. So you can, off you go, buddy. No charge for you. So the idea that would be a criteria for determining, well, guilt or innocence in this case, borders, well, not borders. It transcends the ludicrous. Even though none of the other salient facts it came down to. So the burden of proof was, you got to prove the dude was rock hard. You haven't got any photographs to prove it in a change room, by the way. You haven't got any photographs to prove it. Therefore, there was no intention by this guy to sexually harass the women in the change room. So off he goes. But you'll notice here that there's assumed intent. They're playing the intent game again. Well, let's forget about the facts. What were the intentions? Well, we can't prove or know one way or another. So we'll just go into the ideological sort of twilight zone and just assume it. Now, prosecution, you have to prove. We've now established that only a rock hard on is going to be the evidence that assumes that he intent. If you can't prove that, the issue about the hard on, then you've got then his intention was not to do it. We can just say that. Now that obviously corrupts and subverts the whole concept of evidence and facts and all this sort of thing. So now the first time, I used to, I haven't recently, but I used to spend quite a bit of time going into court, especially with contract law type things and preparing documents and going in with the lawyers and that sort of stuff. And lawyers, not often, but I remember, a few times lawyers trying it on, but Jimmy Jack intended to do such and such. And the judge would come back straight away. Where is your evidence? Show me the evidence. Show me the facts that's your assertion stuff. And that's it. The lawyer would shut up and sit down and don't waste my time with nonsense. Mr. Smith, if you're going to come at stuff like that, you better back it up with facts, hard facts, bits of paper and they couldn't. So, but they'd sometimes try it on. Now it's different, very different in ideological court that's got rabid ideological fanatics running around, such as the divorce court as an example. So I was watching this case in a divorce court where the father had been denied seeing his children, and he was clearly quite distressed by that, and I was watching the guy, and I was sitting in the viewer gallery and watching all this go down, and the guy said, "Was no evidence that I've been guilty of any wrongdoing, and I've got 5 witnesses that said that everything's good and so on, and I had a close, loving relationship with the children and so on." The judge just disallows that. No, I'm not accepting that evidence. It wasn't on some bullshit sort of administrative point. And then says, anyway, I'm not gonna let you see the children because you intend to harm them. You intend to harm them. What? Yeah. And the guy was, this father dude was incredulous and speechless. I mean, what do you even say to something like that? And the guy had enough, like he's in the witness box or something, and he had enough wherewithal. So, well, what evidence do you have to support that? And the judge just sort of looks around, not expecting that comeback. Judge said, well, because I say so. That was it. So this father was denied contact with the children purely on the basis that this assumed intent thing. Now, the divorce courts are just, again, ideological insanity on steroids. So you kind of expect that nonsense there. But that sort of level of nonsense has now crept into every other court. Sure, there are places you might get a rando effect where this judge, they haven't been able to fully install ideological fanatic judges into every court. So you do get a rando effect. There may be a judge that isn't like that, and then the further you move up the food chain to appeal courts and Supreme Courts and High Courts, then the less likely it is that you'll come across this ideological insanity of ascribed intent. But as more and more judges are being replaced by ideological fanatics, you will more and more see this. Now, if you look at, say, and you can see this with some of the law academics that are say, get dragged in front of Congress in the United States, there are law academics there who shouldn't be teaching anything. I mean, they shouldn't be teaching how to push a broom, for goodness sakes, and they are righteous to a fault in believing that facts and evidence are Nazi ways of conducting legal affairs. Our ideology, victimhood, ascribing intent based on ideology and relative victimhood and social power. These are the issues, and anyone that does not make a legal determination based on those things is a Nazi, maybe even Hitler personally. So we're seeing the entire establishment being infiltrated by people who have those views, and they're placing these judges everywhere. And so the last place you want to go to have anything dispute adjudicated is in a fucking court. And you see this in the lower courts as well. I watched a case where some neighbours were disputing a fence thing. The one neighbour just decided to go off and do their own fence without reference to the agreed fence design and so on. So and so the judge, in listening to it, said, "Well, look, I agree, Billy Bob, that you shouldn't have to pay because the other guy just went off and made his own arrangements, and that was contrary to the agreement you had. I get that, but you're obviously wealthier than him. You've obviously got more money than him. So why don't you just pay it? Why are you even letting this get to court? You should have just paid this guy, the difference that he wanted, and look, the facts don't matter here. You're a better educated, you're a wealthier guy, so you should have just paid him." What? So we're seeing this in the lower courts, in the mid-level courts, and many of the upper courts now. And if you look at the decisions in, say, the US Supreme Court, that the affirmative action appointments, Sotomayor and Kagan and Ketanji Brown Jackson, you look at the way they vote, they vote with the ideological pretty much every time. I mean, you may get some exceptions, but it'll be rare. So this is something that is a problem all across the Western world, and this ascribing intent. Now, not everyone has the financial resources to make the appeals if a lower court decides to do the... Now, if the lower court makes a particularly bad decision, an ideological decision top to bottom, they'll also try and prevent the aggrieved party from appealing that by putting all costs on them and demand they have to pay in 7 days. Really letting them have it, sticking it up them, just to prevent them from appealing it, as in to exhaust all their financial capacity. But this is going both ways. It's not just they're using intent to go after the people they don't like, January 6th or whatever. You intended to make an insurrection, but they're also going after, or also exonerating criminals on their side, BLM and so on. Transgender people also exonerating or saying, well, their intentions were good, so we're not going to throw them in prison. But the Christian who's saying praying silently 100 meters from the abortion clinic, we're going to throw that motherfucker in prison because he intended to be Hitler. And they're just doing, and we're seeing more and more of it, and it's very, very scary. You've been with Tassos today, your Pushback channel. Thank you for listening.